It's going to be a little bit of an uphill battle because obviously, first of all, the case is being brought, in connection with the political narrative of the weaponization of government and the DOJ, which is a perfectly legitimate political claim. However, on the legal X's and O's of the case itself, there's a couple of things. Number one, if there was probable cause technically to do the search, the fact that they should have used a subpoena, by the way, which they should have, they didn't need the draconian measure of a search warrant, which is when you think the stuff's going to be destroyed or, organized crime cases, narcotics cases. But the reality is that doesn't translate into a claim in court if there was probable cause. Then number two is the irony of ironies. There's going to be some type of prosecutorial immunity, and I'm chuckling because of the irony of that.
Yeah. Yeah, and you remember, you're flashing back several years ago now, when the Attorney General, Merrick Garland, said that he had authorized this FBI raid. Gerard, any luck that Donald Trump would have success in actually bringing this lawsuit against, a Department of Justice that's serving currently under a Biden administration?
It's very difficult to do that, as Doug Burns just said. There is the immunity issue, but it's also notoriously difficult to bring claims for malicious prosecution or abusive process. Something really has to go off the rails for that to be successful. And it's beyond mere accusations of malice or ulterior motives. You have to really prove that that is what contributed to the decisions made at the Justice Department. And while we have political posturing, while we have a lot of anecdotal evidence, so to speak, that that is what happened, we haven't really seen in the last 2 years anything to prove that to a reasonable juror that what Merrick Garland or the DOJ did was done for ulterior motives and not under any reasonable probable cause basis to go on with that prosecution. So it's a very much an uphill challenge, but nevertheless, it is making the point that Donald Trump was subjected to different treatment than other people who have been accused by the DOJ of similar offenses.
Well, let's talk about the strategy of this all. Perhaps it doesn't go anywhere, or it's an uphill battle as we've heard it being described here on this interview. But the notice of claim was filed a day before the 2-year window for Trump to seek damages expired. Why do you think that is, Doug? Why would Trump's legal team wait until the day before the window expired? Is there indeed maybe some sort of legal strategy behind that?
That's a really good question, Sean. And having practiced law as long as I have, along with my colleague and friend, the fact of the matter is they were probably discussing bringing the case. The lawyers had it, tickled, I guess, as we call it, the date to file the notice of claim. And they did it to preserve their rights, perhaps as they continued discussing it. But the reason you make such a good point is they may not end up actually filing the case. And then they get the media and political message to continue that there has been weaponization and, as Gerard said, differing standards of treatment. Again, to me, when it happened, I couldn't believe it. My wife told me that her sister indicated that the president's home was being searched with a search warrant. I said, that has to be wrong. I couldn't believe it because, again, broken record, you can issue a subpoena for the records. Did not have to do a search warrant. But again, it doesn't translate into a claim that you're necessarily going to win in court.